Is that right? Welcome back to Truth and Transparency. My name is Lana and I'll be your host. This is going to be one of many. So, the thumbnail here, it'll be a new playlist. This will be all the unsealing of the documents. So, it'll be a seal or no seal, is the name of this playlist as it will get started. And this is the defense and state's reply to Judge Hippler's first batch of, I think it was 43 documents. So, again, good morning. It is August 27th, 2025, all day. Make yourself known. Let me know what you think in the comment section, or if you're watching this live, chat with your chatters. Be kind. The state and the defense actually turned in they filed it on the 18th, both of their replies. So they both went out on the same day. Here is the state's response. I'm going to actually show them side by side. The state has a little intro, unlike the defense, really didn't have an intro. So this is for all the public documents that were part of the public record that were either redacted or sealed. Hippler is going in reverse order. And so here we see, comes out of the state of Idaho by and through the Latah County prosecuting attorney, and hereby responds pursuant to the court's August 4th, 2025 order regarding sealed documents. As a general matter, beginning early in this investigation, a number of individuals associated with this case were identified, then subsequently harassed, stalked, and threatened by members of the public. The majority of the threatening behavior occurred via various social media platforms. There are also documented instances of identified individuals being physically followed and surveilled related to this case. There is also one instance of physical trespass. Interesting. Property, and one instance of property damage, vandalism. Go Vandals. Go Vandals. I mean, who was vandalizing? I mean, was that the people that were pissing on the house? I have no idea. But I'm trying to think of what they're referring to where people were vandalizing things. The only thing I could think of is there was a report that students were pissing on the 1122 King Road house. Due to this harassment, stalking, and threatening behavior, previously identified individuals have had to take extraordinary actions, such as filing police reports, moving residences, hiring private security guards. Who can afford that? Hiring media consultants to track online harassment. You guys know how much it costs to get yourself scrubbed from social media? If you were to go see like a social media consultant, you know how much money they will want to charge you to like scrub yourself from the internet? Yeah. Look into it. And so forth. We are also aware of an individual who was inaccurately named as a suspect by a member of the public and then subjected to online harassment. In one instance, the harassment was to such a degree it led to a defamation suit. See Schofield versus Gilliard. That case just won't go away. Southern Grit, you're absolutely right. It is about $40,000. I mean, talk about why are you giving this any air? I wouldn't even be mentioning this to give it space. Based on the above, well, last time I checked, harassment, stalking, and threatening, those are like crimes. So why hasn't anybody been charged with any criminal act? Based on the above, the release of full names and contact information, which would identify potential lay witnesses, could subject these individuals to similar harassment as described above. I don't think that people's names should be given out. I don't think their addresses should be given out. I think the first initial and the last initial would suffice. So, releasing potential lay witnesses' names and or addresses would constitute an unwarranted invasion of personal privacy. And see, I like how the state says full names. You know, it just doesn't say names, period. Just full, so just like how Moscow Police Department put out the initials, I think that's fine. So, pursuant to ICAR 32I3, the state moves that any potential lay witnesses listed in any court document should be redacted, and pursuant to 32I3A7, that any potential, or I'm sorry, personal data identifiers also be redacted. Absolutely. Absolutely. This is like a no-brainer. Nobody's addresses are going out there. No-brainer. Absolutely. Nobody's full name should be going out there. Totally agree. Yeah. But I'm going to play a flip side of the coin. You got people starting to do this, right? People are always going to try to guess who so-and-so is. So-and-so's this, so-and-so's that, so-and-so's this. I mean, but threatening, stalking, harassing, I would say start filing some police reports. That's the, I mean, fuck. Again, that's just my personal take. Okay, so now the state identifies each document by date, name, number, exactly how Hippler wanted it. Okay. So we have the states there. As you can see, this is Ann Taylor's filing, and it just says comes now, and then we're just going to start listing these off. All right. So how this works is each one that you're going to identify. So number one, oopsies. They would just copy, cut, and paste what Hippler was saying. So this is the 7/24/2025 States Exhibits S1 through 5 through 7/23/2025 sentencing hearing, which included photographs of each of the deceased victims and a photograph of the 6 victims together. So there's 5 exhibits total. The state has no objection to unsealing these items. Okay. So number one, we're going to put a defense and state column, and the state has no objection to number 1. See that? So we're keeping track. The defense has no objection to unsealing. Now, if they were all only like that. The second one, because again, we're moving backwards. It was 7/23, the orders modifying / amending no contact order. The state has no objection to the unsealing of this item. The no contact orders 7 should be redacted to protect the names of the protected persons pursuant to. Absolutely. So the defense has no objection to unsealing, and then they're both citing. It's interesting. I always like to pay attention. So the state is citing, or I'm sorry, the defense is citing 32I3A 1, 3, and 5 as to the reasons for the no contact. So I like to just pay attention to what the state said is where the defense is 3A1, and then they say 3A7. So it's just interesting when you see where the two are coming from, the sides. But ultimately, it's for the same reason, and it's to redact right here. 1, 3, and 5. The state lists 1 and 7. I think that that's just going to be what it is. You're not going to know the names. I think we know who it is. They should have a protective order. Number 3, opposition to motion to vacate non-dissemination order. The defense has no objection to unsealing the non-dissemination order, the motion for it. The state, in exact same fashion, the state has no objection to the unsealing of this. They shouldn't. Number 4, this is sealed Exhibit S1 to state's response to defendant's 24th supplemental request for discovery. So this was late in the game with this last supplemental request. And so going back again in order, the defense has no objection to unsealing with anticipated witness names being redacted. And this had to do, again, they're citing ICAR 32I, A1, 3, and 5. There is continued media attention, including social media and online sleuths. You know what? I'm going to take, I do believe in a term of like bad witches, good witches, right? All you witch lovers out there. Well, there are good sleuths out there and there are bad sleuths out there. Okay. But nonetheless, Ann Taylor's team is talking about online sleuths. But there's public harassment. But online media reflects continued attention and comments that may be offensive and harassing and impact safety and livelihood of persons named. So there's people that are named in the state's response to defendant's 24th supplemental request for discovery. Okay. And the state says the state has no objection to the unsealing of this item, but requests the following redactions to state's Exhibit S1. So they actually give us, remember this line by line? So you got to give the nod to the state here. They're like, okay, item 441. This would be, you know how Ann Taylor was going in order? You're numbering something like number 1, number 2. So when you're filing these supplemental discovery requests, the way that I see this as supplemental request 24 had item numbers that were in the 440s. Okay. And so item 441, the potential witness name identified in this item should be redacted. The date of birth should be redacted. All of the date of birth should be redacted. Always. Now I'm going to look at this now. The state is like, we want you to redact the Bates numbers. And I think that that's interesting because that is going to make it harder for someone like myself to request in the future down the road if I ever wanted to do FOIA requests. And I'm like telling people to go to certain Bates numbers. It's a lot easier to pinpoint what I want. So, but this item 442 is the potential witnesses identified in this item should be redacted. In addition, the Bates numbers for this item should be redacted as this is attorney work product. Item 443, the potential witness identified in this item should be redacted. 444, the potential witness identified in this item should be redacted. Notice they just say witness, not witnesses. So this just pertains to one person, multiple people. The potential witness, 1. Which I agree. I think that initials right here. In addition, the AV number should be redacted as this is attorney work product. Again, it would just someone that knows what they're looking for and what they're doing. All that type of stuff would help somebody to be able to locate stuff. Next, number 6 is the guilty plea advisory form completed by the defendant. The state has no objection to the unsealing of this item. In addition, you look at I skipped one. The sheriff stuff, the sheriff's return. They just want the initials. But the defense has no objection to unsealing with the redaction of just the name. So the The guilty plea advisory form completed by defendant. The defense has no objection to unsealing this. So this is going to become public. Like, check. No doubt about it. Number 7, the second notice of filing defendant's additions/objections to the juror questionnaire. Now, the state has just plain as day just said the state has no objection to the unsealing of this item. So what I thought was interesting here is that when you compare that answer, which is just a simple no objection, when you compare that answer to then what the defense types up, the defense objects based on the language. So they're using ICAR 32G8. All renditions of the juror questionnaire were sealed and not for circulation. Portions of the questionnaire contain sensitive information related to mental health. And remember, I told you guys, if anybody asked me, why would you ever take a plea deal? Why would Brian Culver take a plea deal? I said, I think a big part of this has to do with stuff that started developing in this, the mitigating phase, and talking about Brian Culver, his family history, and his life. Because, and I think that I'm on the right track when I saw this and I saw this, and I'm like, so there's questions that pertain to sensitive information related to mental health, and other portions contain potential witness information. The defense submits that ICAR 32I3A 1, 3, and 5 apply to people having names revealed. There is continued public and media scrutiny relating to this case, and keeping names protected will prevent harm, harassment, and sensitive information from becoming available or made or as media fodder. And it's just to me that this is interesting. I don't think it's going to win. I think the state's going to win. Next up. Number 7 is the second notice of filing defendant's addition/objections to the juror questionnaire. The state has, again, no objection on sealing this item. Even though this pleading did not or does not contain that information, the defendant suggests that all parts of the questionnaire be treated the same. I'm not sure what this means. This is your sheriff's return. Again, they just want the name and the address redacted. The sheriff return here. The state believes that this was a defense filing, as the state does not have a record of this filing. The state leaves the unsealing of this item to the court's discretion. Okay. So 8. Number 9. This is a sealed order on defendant's offer of proof for alternative perpetrators, unredacted. Okay. This is the big one people are talking about. So the state notes that a quote unquote redacted order on defendant's offer of proof, RE alternate perpetrators, was published on 6/26/2025, which redacted footnotes 2 and 4. The state requests the following redactions to the unredacted order. So remember, there is an unredacted order and there is a redacted order. We all got to see the redacted order. Okay. And as Hippler makes it very clear here, I'm talking about this unredacted one. He is going to unseal the unredacted one. Okay. So that's what is number 9. Has nothing to do about the redacted one. This is about the unredacted one that the parties got. Okay. And so the unredacted one, this is the only issue that the state wants, is that everything can be unredacted, except when you go to footnote 2 and footnote 4, the witnesses' names should be redacted. But everything about, you guys remember that order that came out? It was like all those footers. Okay. And now, so all the state's saying is that just go to footnote 2 and go to footnote 4 and just take out those witness names. Okay. But everything that's in it, so it'd be like blank, just like how we're reading these reports, blank and blank did blah, blah, blah. Like but everything about the blah, blah, blah would be there except just the names. And the defense says there is continued media attention, including social media and online sleuths and public harassment reasons. Online media reflects continued attention and comments that may be offensive and harassing and impact safety and the livelihood of persons named. Remember, this is the defense that named these people a month before trial. The public copy contains all pertinent information. I'm going to disagree with the defense 100%. No way does the unredacted contain all the pertinent information. I want all the names redacted. I don't need the names. Okay. I want to know the information on what would possess the defense, right, to go forward with a third-party culpability. What's the fruits? What do you got? Take the names out. I don't want the names. I don't care about the names. The process of here, just like the process if you're going to say you have an alibi defense, okay? The process here, you're going third-party culprit. Who gives a shit about the names? Okay? Yeah, they shouldn't be there. But this is what you did a month before going to trial. To say that everything is pertinent in the unredacted version, I just completely disagree. Like 1,000,000% disagree. So everything should be unsealed except the names. You know, because if you remember, guys, Brian Colbert did not have private attorneys. Okay, Brian Colbert had public defenders. Who paid for those public defenders? Who paid for the public defenders? The same people that pay to prosecute him. We, the people. So you bet your bottom dollar, I want to know what the defense attorneys could possibly be doing to maybe drag this all out for 2.5 years, okay? And do things like this, right? We have the right to see that. The names, yeah, I don't think the names, that's, no. Number 10. This is the sealed Exhibit W to defendant's 24th supplemental request for discovery. So the state requests the following redactions to defendant's Exhibit W. So the state gets a little bit more. Let me hit up a little. I want to give somebody a shout out. William Tardy, he is blue now. I want everybody to know that. Congratulations, William Tardy. He's a fabulous gentleman. Yuri's math teacher, he's teaching us all how to add. He turned 5 of you guys green. Look at those 2 men in blue. You guys think I have men in black? No. We make you black and blue. I got men in blue. So, we're going to look at how the state breaks this down. So item 40, 441, 442, 443, and 444. 444. You guys remember that commercial? And again, it's just all about the potential witnesses. So the potential witnesses' names identified in this item should be redacted. The date of birth should be redacted in its entirety. And the state is even just saying, give the initials. If your name is Lana Oriani, it's going to be LO. Okay. Period. So they just because they already kind of talked about it, but this is about the actual exhibit. And that's where everything's at. So now I'm going to spend some time on number 11 because this is the state's amended notice of compliance and motion to seal state's amended witness list. The state just goes out and says, here, this is everybody that was going to be on our from law enforcement witness list. Law enforcement includes also the lab people, FBI, ISP, MPD. So I'm going to point out some stuff. Again, the defense with the unsealing of number W, they just care about the names. Number 11. The state does not object, first of all, does not object to the unsealing of this item. However, the state requests the court redact from ICR 16B6 witness list the names of all non-law enforcement and or non-lay expert witnesses. Okay, so the state wants protected is expert witnesses. Their names completely. Expert witnesses. So the state requests the court redact from is the witness list the names of all non-law enforcement and or non-lay witnesses. The following individuals were potential law enforcement or potential expert witnesses. So no lay people, just redact them, do the initials. And then the state's over here, I think, showing a good faith to say, we're going to put our list in here of our this is everybody that's law enforcement that they were going to potentially call. Now I went through this whole entire list, which is on pages 4 and 5. Okay. And I already started making the most important notations. And here they are. Your plainclothes officers, no Nate Rosendahl and no Josh Tisdall. Holy shit, if they weren't on Ann Taylor's, then she did not know this case. Those two gentlemen's reports and what they say happened is everything on leading up to possibly being able to defend your client. Could not believe that no Nate. Remember, Nate has something to do with the dog. But he's also, and no Nate, no Josh. Those are the plain clothes, undercovers, hybrid car. Also, the guy that said that he found the glove because of Chris McDonough, okay, and where it could have actually been located and where Chris McDonough actually found it versus where Payne would have been looking. I mean, to see that the state was not calling either of these two people, they better have been on Ann Taylor's list. So you can go through all of these names. And I think it was actually really smart of the state to just, hey, these are all the people that we were going to call from, or potentially call from law enforcement. And Dawn Daniels is on there. Let's see. I think it's interesting when you can see like who isn't on there. And when you see people that aren't on there, like, for example, goes in alphabetical order from last name. So you can just go right to the last name. Now this is Shannon. So this is the last name here. Lab Girl. Lab. The Barnharts. Dustin Blaker. Darren Duke. Michael Douglas. Look at that. He's going to bring Catherine Zeta-Jones over. There's Dawn Daniels. Congratulations, Dawn Daniels. She is now captain. No Gloves Gunderson. Look at Rob Hale. Oh, there's Emil. Car guy, FBI. John Lawrence, retired. Roger Lanier. You know who I don't see on here? Dollinger. Barrett. Look at no Dollinger, no Barrett. Those are really important names. They'd be on my list. The L's. There she is. Catherine Mabutt. Come on down. Shake it, mama. Now here's your sheath people. Chad Wilford, one report only, and that's your sheath transport, as well as Justin. Remember I told you it's like Tupperware. Tarenti. Sheath transport, and Macy, Casey Macy. Where's she at? Macy Casey. I don't know. There she is, Casey Macy. Those are your three names that have to do with the sheath. a lot more that I'll say. Corbin Smith, first responder. Eric Seat. Rosinski. Danny Vargas. Mike Van Leuven. Look at this man right here. Where's Gary Tolson? Where's Tolson? Tolson, look at this. No, Gary. No, Gary. Get out of here, Gary. Gary, the state wasn't calling you, man. You were liability, son. Well, so is Van Leuven. And Taylor put Gary Tolson on her list, no doubt about it. She wanted his training records. Look at that. No, Gary Tolson. That's a pretty big name not to be up there. I'll be adding Gary Tolson here. Very, very interesting name not to be up there. Danny Vargas just happened to find every single big bomb in the videos. November 15th was a very memorable day for Detective Danny Vargas. Anyways, that's just the states saying, hey, these are all the law enforcement people. Now, the way that the defense was looking at it is as far as that goes. The state's amended notice of compliance and motion to seal state's amended witness list. The defense objects to lay witness names being released based on, so they have the same thing. There is continued media attention, including social media and online sleuths. Woo! But we are the good witches. We are the good sleuths. Is that right? Online media reflects continued attention and comments that may be offensive and harassing and impact safety and livelihood of persons named. So pretty much the same. Now, number 12 is the court minutes for closed session RE motion concerning alternate perpetrators. Okay. The state has no objection to the unsealing of the court minutes regarding to the closed session in relation to alternate perpetrators. So the state breaks it down and they say, hey, from this timestamp of 1:25:05 p.m. to 1:36 and 17 seconds p.m., we want this part redacted. Oh, I'm sorry, has no objection to this portion. Then the state objects to the unsealing of the court minutes from the closed session starting at this portion, 1:36 and 17 seconds, C, to 2:07 and 44 seconds, pursuant to ICAR 32G 1, and as it involves an ongoing investigation proceeding. And let me tell you what this means. Okay. If you're going to go spreading the word that this has to do with an ongoing investigation into the third party alternate perpetrators as being involved in this fucking case, you are so wrong. And you'd be spreading false information. During this session, okay, the motion concerning alternate perpetrators, there was a couple things that were talked about. One of those things was the special prosecution into the leak that happened, aka the Dateline leak. Okay, it's not just the Dateline leak. There's been leaks happening in this case. If you didn't see my live last night, go check it out and go to the last 20 minutes of the live, and you will see me put out a report pertaining to the Idaho State Police looking into the grand jury leak. And that has incentives around the Gonsalves family. But the Gonsalves family put out back in October of 2023, they put out in defense of them, they were like, this is crossing the line. Somebody fabricated screenshots. And I know that you can do that. It's happened to me. But the police should be looking into it. The police just did absolutely nothing. Because, well, I'm not going to lie, but if I was Shannon Gray and I was the Gonsalveses, I wouldn't be answering the police's phone call. No way. I'm not getting involved in your shit. Go. Like, solve away. But we don't have any part of this. But they posted on their family Facebook page screenshots. And from me reading the report, it made it seem like the Gonsalveses never got those by the police giving them to Shannon Gray. So the question would be like, well, how did you ever get these? Like, we didn't supply you with what the person that reported this to the defense side and the state side, and provided both of the defense and the prosecution with the same information, then that was given to Payne and Gilbertson, and then Gilbertson and Payne reached out to Gray. And on the same day that they reached out to Gray in October, I think it was like 12, 2023. Then there was a post posted on the Gonsalves family Facebook page, and it had screenshots, and Payne wrote a report on it and just commented that he saw it and that there was nothing further. So this has to do with, this is not about, it has to do about the leak. Because when you're in a motion hearing and you're talking about all different types of things, right? And the closed portion pertain to the leak, which happened at the end. So look at this timing. So this part is the third party culprit, alternate perpetrators. At this part to this part, we want that out. It's because there's names. And then right after that is when we got into talking about the special investigative special prosecutor and into the leak. So that's what this is about. The state has no objection to the unsealing of court minutes from the closed session that begins from 2:07, with the request that the potential witnesses named at this point is redacted. So the state just went and was really specific about what that was about. And that has nothing to do with these third-party alternates being still investigated, okay? Come on, man. You got to know what that motion hearing was all about and what it all entailed. And there was two things being talked about. Where is that? There we go. The defense has no objection to unsealing the court minutes in its entirety. So it's interesting because I don't know, this kind of clashes that they wouldn't want the names redacted, but the meeting minutes have the names in there. You know what I'm saying? So that kind of threw me for a loop there. In that if that transcript goes out, it's going to have names in it. So number 13, the state's motion to seal ex parte filing, and it was the out-of-state witnesses. The state has no objection to the unsealing of this item. The defense has no issues. Again, these are stuff that they're going to agree on the dot about. When it's like the no objection to unsealing it, it's going to become unsealed. Where I believe Judge Hippler is going to take a look and say is when the two parties aren't agreeing, he's going to then look at them. And then remember, he wants a factual basis and something based off of law. Okay. Both. Number 14 is the state's S1B to state supplemental response to request for discovery, expert testimony. The state has no objection to the unsealing of this item. The defense has no objection to the unsealing. Now, again, I'm curious, is there a name involved? Because I thought they wanted the names redacted that were experts, okay? So, again, number 15 is, this is the A, that was the B. State supplemental response to request for discovery, expert testimony. Again, the defense has no objection, and the state has no objection. Number 16, again, this is just has to do with an exhibit. So the defense has no objection. The state has no objection. This all pertains to that. This the state's supplemental response for request for discovery. So it's what they're supplying, and there's exhibits. Now we go to the sheriff's return concerning witness YR, and the state believes that this was a defense filing. So that even more shows mainstream media they do not know what they're talking about. So I want everybody to see this. When Court TV was saying, and everybody was spreading the rumors that these sheriff subpoenas were put out because of the prosecution, they were wrong back then. And this is just when you want the ultimate proof, here it is. the sheriff's return, everything to do with all that out-of-state stuff. We believe this is a defense filing. The state does not have a record of this filing. They don't. They did. This wasn't their filing. And again, the defense, no objection. Now, as far as the sheriff, the defense has no objection to unsealing the redaction of the anticipated witness names, addresses, and all personal identifying information. Number 17, sheriff's returns concerning witness R or YR. Again, same thing. It's just about the names. And number 18, defense reply in support of motion for access. The state objects to the unsealing of this item pursuant to ICAR 32G1 and 74-124A, as it involves an ongoing investigation proceeding. Depending upon outcome of that proceeding, there may be fair trial rights implicated. So now we're going to show you that what this pertains to is it's the leak right here. The defense's reply in support of motion for access is that this all has to do with if they were to eventually get to the bottom of the leak. Okay, we're going to go ahead and prosecute. We would have to keep this all sealed for the purposes of that right here. Fair trial rights implicated. Which means people out there that are saying that there is no investigation and blah, blah, blah. That's 100% not true. There is. And you'd be stupid if you were to be out talking. Anybody that would have had access to Brian Kohlberger's phone and pictures and shit like that, and basically everything that Dateline had, I think that they would be a fool to have been talking to the media. There's people that have. Number 19. The defense's reply to the state's objection. So the state objected to defendant's offer of proof. It was the alternate perpetrators and defendant's evidence in support of offer of proof. And the state says it does not object to the unsealing of this item so long as the potential witnesses' names are redacted. This is exactly how it should come out. I completely agree here with the state. It should come out exactly as all the meat and potatoes should come out. We should all be able to see that. Because remember, Brian Kohlberger did not have a private attorney. Okay, we the people pay for public defenders. And if a public defender is going to stretch something out over the course of 2.5 years and get paid a shit ton of motherfucking money, okay, what are you doing? We wanted to know what you're doing. Redact the names of the witnesses that would be in there. I don't believe that they should be harassed or talked, but I want to know why you would ever put forth here's our offer of proof that these are the third-party culprits. I just want to see that stuff. I don't want to see no names. I don't care who the names are. I want to see what you were going forward with, that you would put this in. So, again, right here, the defense requests redaction of anticipated witness names based on this. Okay, perfect, witness names. And I think that that's it, right? So the rest of it's good. So the defense agrees. So that's going to become available. Everything minus the names. Both sides are in agreement. Number 20. The state's motion to amend witness list and supplement expert disclosures. Now, again, this is just so late in the game to be amending and supplementing expert disclosures on 6/12/2025 when those all needed to be done in December of 2024 and January of 2025. But hey, that's what number 20 is. The state does not object to the unsealing of this item so long as the potential witnesses' names is redacted. That's how it should be. I don't think so. there's and that's me saying, well, does that initial sound good? And then the defense is saying, the defense position is that redaction of anticipated witness names is appropriate. So they're both saying the same thing. So this is going to become available. But if you think about it, it may be nothing, right? If the whole entire name is redacted, but otherwise you'd get like initials. And then it would potentially, I mean, I'm guessing it's going to still have what the person was going to be talking about and whatever they're amending. So you're going to have, again, the meat and potatoes. You're just not going to know who was going to be testifying to it specifically. But you're going to know it was somebody in that field. Number 21. I'm excited about 21. It was the notice of filing it was a sealed defendant's amended exhibit chart. So it would be like the list of all the defense's exhibits and whatever they were, defense usually does letters and prosecution's numbers. So like if it was like A, and then it would be whatever they were saying the exhibit is named. I want to see that. Again, the defense, no objection. And the state, no objection. Number 22 is the order sealing state's response to defense motion for special investigation. So again, it was an order sealing state's response to defendant's motion for special investigation. So how it looks to me is that the defense was asking for this special investigation. The defense put in a motion, okay? And this would be the response to the defendant's motion. And it had to do with the special investigation. So the state does not object to the unsealing of this item. The defense says the defense has no objection to unsealing. Oh no, that was from the last one. I'm sorry. Right here. The defense has no objection to the unsealing. Just making sure we're on the. So this is going to be unsealed. (23) Now this was the order sealing defendant's motion for access in objection to court's order. So there was a court order, and at one point, defendants put in an objection to that court order. So you can object to court order. The state does not object to this unsealing. Okay, because the defendant wanted access to something. We're going to find out what they wanted. Okay. Right here, no objection. That's going to be unsealed. So the ones that you're seeing here that are just so, yep, no objection, no objection. Hippler should just go right now. Click, 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 click. Post them. Click, click, click. Post them. Now, number 25. Oh, I'm sorry. Okay, number 24. The motion to seal state's response to defendant's motion. No objection. State has no objection. Unseal. And number 25, I laughed. 6/11/2025, state's response to defendant's motion, RE special investigation. I want to back up right here. The defense has no objection to the unsealing of this, okay? For some reason, the state's response says the state leaves the unsealing of this item to the court's discretion. The state's response to defense motion for special investigation. The state leaves this. And so this tells me, I laugh, I said, that the state is basically pleading the fifth in a way. And I just, for whatever reason, I can't help but think that this, in some way, some shape, they're saying this for a specific reason. Okay. And it's like, I don't know if down the road they want to go ahead and say, hey, we left it to the court's discretion. Like, we didn't say unseal it. We didn't say seal it. We left it to the court's discretion. So this, I really, really want to know what the state's response was. Because why wouldn't they just be saying the state does not object? Why are you leaving it to the Why this one? So it's going to be interesting. I do believe it's going to be unsealed. If it's up to the court's discretion, it's getting unsealed. If it was up to Hippler, he'd be unsealing everything right now. Now, number 26, the defendant's objection to release of privileged and confidential work product. I have to know more about what this pertained to because it's so vague, but usually your work product is your work product. And I mean, so here it is, but the defense has no objection to the unsealing of the defendant's objection to the release of privileged and confidential work product. Now, the state objects to the unsealing of this item pursuant to 32G1 and the same reasons, as it involves an ongoing investigative proceeding. And somehow they're reverting back to this then. When I saw this, I was like, this has to then do with the leak. But if anything, are there names involved in here then? Are they already talking about names? Get what I'm saying? Are they already talking about names? I think there's going to be some name droppage in this shit. Remember, Steve came out and told, I think it was Good Morning, somebody that he interviewed with, and said that if there was an investigation, don't you think they would come and talk to us? Don't you think that they would come and try to talk to us? Well, first of all, if you have an attorney, make sure this is understood. The police aren't going to come knocking on the Gonsalves' doors ever. If you have an attorney, they're not allowed to go do that. Okay? They can go arrest you. All right? But they can't come knocking and saying, hey, Mr. Gonsalves, do you want to talk? That's not how that works. You have an attorney. They have to go through your attorney. If your attorney doesn't return their phone calls or their emails, like they're saying happened in October of 2023. And so this is a good point to show you guys this. Here we go. I want you guys to take a look here. Okay. This is Idaho State Police, Report 199, right? This report wasn't written for almost 4 or 5 months later, okay? 1/18/2024. But the work that was done with this report happened in September of 2023, and actually in October as well. I don't know why he's just saying during September, because I'm going to show you how I know that it's not just September. So during September of 2023, the Latah County Court received emails. See plural there, not just one, but it's saying that they received emails. That means plural. Curious if they're from the same person or not. But they're saying that they received multiple emails alleging violations of the Idaho grand jury rules. Now, let me tell you about the Idaho rules of grand jury proceedings. If you're on the grand jury, you cannot be taking out your phone and taking pictures of shit, okay? It's a secret society. You can't tell people about it, okay? You cannot tell them what went on in it. You sure as shit can't take your fucking phone, okay? And be taking pictures of shit, okay? I don't know if you guys know sports, but do you guys remember Alex Rodriguez? Well, big time player for the Texas Rangers. Then he went to New York and made buco bucks. He married and messed around with Cameron Diaz. I think Mariah Carey. You know, he had parties. And the only way that you can get into his party, first of all, you had to be invited. But when you got to the door, there was a phone gate. You would take your telephone, and you were not coming into that house unless your phone got put into, let's just say, the bucket. Best rule ever. So yeah, check your phone. So here we go. Grand jury. The grand jury happened secretly in this case in 2023. It began talking about the end of April, got it done by the beginning of May. Brian Culver was indicted. Okay. So on September 7th, After receiving the initial email alleging violations of the Idaho grand jury rules, I emailed the sender, who's redacted. Okay. I meaning Darren Gilbert, blank requesting more information. I asked her, or I'm sorry, I was advised, I advised her I was assigned to the investigation and wanted further clarification. And I just can't believe that you wouldn't call first. I'm shocked that it was sent in an email. I'd be like, who the fuck is this? I'm not responding to this. Call. He emailed. Anyways, he wanted clarification. So he's like, I advised her I was assigned to the investigation and wanted further clarification regarding the screenshots she had attached to the email that she sent to the courts. Okay. So everybody want to know what was going on back then with the whole grand jury shit? Here it is. A woman emailed the courts, and in the email, she had attachments that we call them screenshots. Now, Darren Gilbertson hits her back up in the emails and says, I want further information on this. He said, I received a follow-up email from this girl on the same day, or this boy on the same day. Now we can say that she's a she. She stated, the screenshots originated from blank, 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 and blank, blank. So first, it looked like it could be potentially two different people, right? Or like a social media site and a person. But I was like, okay, let's go with two people. She provided email addresses for both. And I was like, okay, boom. Email addresses, 2. For both, 2. Okay. See email attachment for full information. I emailed both individuals. Okay, now we can say, boom, they were considered individuals. On September 12th, requesting contact to discuss the conversations. Okay, these were conversations. These screenshots. The screenshots were conversations captured. So it's like if I'm texting with you and I take a picture of our back and forth, okay? Or if I'm in the DMs with you and I take a picture. But guess what also you can do? If you guys have been paying attention to the trials that I've covered in the Karen Reed case 1.0, I think I found fraudulent text messages that were put into evidence between Allie McCabe and Colin Albert. And I just showed where it looked like and how it looked like these were manipulated, because this would not be how this would. There's two things that were missing that I believe would have been there if they were real, and somebody forgot to add that. But anyways, so this broad attaches the screenshots of messages back and forth. And so when Darren Gilbert reaches out to these two people and with these email addresses, he says, I did not receive any reply or contact from either of these individuals. Now, number 3, big one right here. On October 12th, this is why I say, boom, fuck you with the September shit. It was September, October, okay? Boom. On October 12th, 2023, Detective Brett Payne of the Moscow Police Department and I emailed Shannon Gray. Now, this is why I'm bringing this up, because of what I was just talking about with this special investigation. Now, according to the Idaho State Police and according to Detective Brett Payne, they reach out to the Gonsalves' attorney on October 12th and requesting a meeting. And now this is how you have to do it. They can't go to the Gonsalves family because they're represented by an attorney. So you go to the attorney and you say, I want to talk. This is why you talk through an attorney. Okay. When people are like, why would Jack D get an attorney? Do that for your kids every day. We live in America, and that is a right of ours, and it's afforded a right. You know how many people would die for that right and have, if they could be in other countries and having that? It's to protect you. It's not because you're guilty. It's to protect you from incompetency, from people that don't know what they're doing. Okay. From people that could spin your shit. Okay. A lawyer would tell you, no, clarify that question because that's too murky there. Ask him it again, but you need to clarify this. You're not, that's the type of shit that they're going to be able to do and help you with. It's even if you think that the officer is the best guy in the world, because guess what a good officer would do? Hey, you have the right to an attorney. If you want an attorney, be here. Here, call up an attorney. They should have no problem with you having an attorney. Right? They're an American just like us. They should say, yeah, that's your right. And I can't give you advice on what to do, but they shouldn't be stiff arming you when you say the words, I want to have an attorney here and I want to help. I have no problem helping you, but I just know this is a right of ours and I would just like to exercise it. So here, Mr. Gray's contacted. Exactly how the police have to do it. So check. Mr. Gray is the attorney representing the family of Kaylee Gonsalves. We requested to speak regarding the screenshots showing conversations that appear to reference, and then it's one of their names, and then it's in a capacity of it either is a sibling, a mother, a father, blank, comma, of Kaylee Gonsalves speaking to individuals about the grand jury proceedings. Now, what this tells me is that once the state would have received these and once the defense would have received these, because both sides were sent them, and then they were given to the police as well, they know who was on the grand jury, guys. Okay? And so all it would take if I was doing it is to look at the name of the person that's in conversation and, hey, were they a grand juror, first of all? Now, let's say that they weren't. Well, we also know that there are such things as people use fake account names in Facebook, all right? But let's say just right off the rip, oh my God, yeah, this is a name of one of our grand jurors. Okay. But so they asked for this meeting. All right. We did not receive any reply or contact back from Mr. Gray regarding our request. And so this is where when Steve says, and I want to explain this to him, I'm saying, listen, they can never come to you and ask you. They will never come to your house. They cannot come to your house. They will not talk to you. That's not how it works. They have to go through your attorney. And then Shannon Gray is supposed to tell his clients that this is what happened and they want a meeting. But there was just, according to the police, no response. But the same day, Officer Payne is just lurking around in none other than the Gonsalves family Facebook page. So on October 12th, which is the same day as here, the police are saying that I was forwarded an email. So then it was like, okay, now we got some. I was forwarded an email showing screenshots from a Facebook page that is titled the Gonsalves family page. The screenshots show some of the same screenshots that were forwarded to the court by blank, one of the people up here, that person, the originator. Part of the posting stated, now listen, this is what is interesting. According to the police, when they hit up Shannon Gray, they did not supply him with, from what this report says, they did not supply him with the screenshots. They just simply said that we request to speak regarding the screenshots showing conversations that appear to reference blank. Okay. Now they would have to make this a little bit more clear to say we hit him up and provided him with the screenshots. Okay. I'm just curious, or did you just describe what you had received? Because that matters to me. Regardless, what the police then say is that this post had the screenshots uploaded to the family page. And it said, the screenshots show some of the same screenshots that were forwarded to the court by that person. Part of the posting stated, we recently were made aware of some messages claiming to have fabricated text from blank. And now that's either going to be from Steve, from Christy. I mean, I think that's like, this is like their post that they put out. And so there's a family member's name there, as well as trying to incite others to spread lies. While we understand the internet is a big place and people are free to say whatever they would like, I mean, they are and they're not. Like, you can't say whatever you would like. I mean, you can, but there may be consequences. We personally feel a line was crossed. And the reason that they feel like a line was crossed is because they are alleging that these are fabricated text messages or communications, however they are, if they're in the DMs, if they're text, whatever, email, whatever they are. The family comes out and says, basically when they're talking about a line being crossed, they say the word right here, fabricated texts. And we would like to pursue further action. If anyone knows any more about these screenshots, knows who created them, what they said, etc., and would feel comfortable sharing with us, we would be extremely appreciative. Well, why wouldn't you just have Shannon Gray get all that information? Well, because maybe the cops wouldn't give it to Shannon Gray, even if he was to say, hey, what is this about? But the question is, if the police didn't give the screenshots, ready? If the police didn't give the screenshots to Shannon Gray, then how did the Gonsalveses get the screenshots? That's my question. Is that if the police actually attach those screenshots, then they're idiots. Because that's how they got the screenshots and then they put them out. Okay. But if the police did not send Shannon Gray the screenshots, then yeah, how did you get those? Because it would look, and then depending on, you guys, I've been through so many scandals with people on fucking YouTube. When you take a screenshot and it's your phone, and it's your phone. If I'm looking at it from my phone and I'm in a text conversation with you, my shit is on the right-hand side. So if I take a screenshot and it's my phone, okay, my texts are on the right-hand side. Whoever you're ever going to be texting with, I don't care what app device it is, their shit's on the left always. You would have to, if you're going to truly try to pull this off and you want to be some really good sleuth, maybe I should make a channel that's all that here, trolling 101. But to see the screenshots and how they looked, you're going to be able to tell who produced it. Did it come from a screenshot of the, what side? Who's the sender? You're going to be able to tell a lot. You're going to be able to tell also the color of the background. But anyways, this is what they said that they did. This was the last information that was received about the allegations of violation of Idaho grand jury rules. They did nothing. You want to know why? They couldn't do anything, right? I bet you they could have. But Shannon Gray didn't talk to the cops, did he? Shannon Gray didn't even respond to the cops, did he? That's what you do, folks. You want a case against you? Talk to the cops. You don't want a case against you? Don't talk to the cops. Shannon Gray's advice had to have been, we're not responding to this. You understand that? Anyways, then I just throw this up. When did Ann Taylor file her motion about the grand jury? Go check that date out. But so I disagree with, hey, nobody's come and talked to me. Nobody's done this. This Steve is calling out you guys and saying, yeah, actually, we did come to your lawyer before and we don't get responses, but you guys go to Facebook and then you guys post the stuff that we don't even send you. So how did you ever get that stuff? And now you're saying it's fabricated. You know, if we didn't send you the screenshots, how are you able to track this? How did miraculously you get them? Some of the same that we were sent, and upload them to your page. And then Steve could say, well, we got sent the same thing and we were getting blackmailed or some shit like that. I don't know. People on the internet suck dick. That's all I know. But anyways, long story short, the grand jury was 100% somebody from the grand jury 150% leaked information. Like that means somebody from the grand jury spoke about the grand jury proceedings to somebody. You're not supposed to do that. In the Karen Reed case, a woman just got charged in federally. She cut a deal. Go check it out. Social media is a bad place. Okay. And I'll tell you this. Don't think for a second that people aren't trolling Gonsalveses, because they are. People have nothing better to do in life than fucking troll. Don't feed it. Don't talk. Delete it. Block it. Don't put out stuff like that. Delete it. Block it. But when you feed the trolls, that's what they feed off of. When you're not giving them anything, they have to go somewhere else. Okay? It's the same thing like flies, man. Keep your house clean. Flies don't come. Unless your son keeps the door open and fucking flying around in my house. I'm like, what the fuck is going on? Anyways. Intelligent people don't talk about people. They talk about situations. They talk about things. People that you need to stay away from are always the people that want to talk about people. Run. All right. Moving back here to number 27. So, last thing I want to say about number 26 here. So there's clearly a lot of what they're trying to say is privileged and confidential work product that would be revealed because about people having access to things. They're supposed to be turning it over to a special investigator because the whole purpose of this is to find the leak, right? Well, Dollinger just came out and said that literally in one of his last interviews said that they're not responsible, for the leak. And I have 100% Steve Gonsalves and Shannon Gray's back on this, is that put this timeline in perspective. Shannon Gray went and caused a ruckus and accused Bill Thompson and his staff of being the leak of stuff back in January of 2023. Okay. Came out firing and saying, you guys are leaking stuff. Your arms of chairs. That means cops. Okay. Ann Taylor's not even on the case yet. So then you go back to like the Delphi case, and the Delphi case had leaks over the past 5 years because guess what people did? People that were out looking for the bodies of the girls. Okay, they were out there with their phones taking pictures of shit, and then they came across the girls, and they took pictures of stuff. They took pictures of they took pictures of a lot of things. Okay, and wait till me and Bella get into talking about that case. But the leaks were way before there was ever even a defense team, even before there was a defendant. Okay. So it couldn't be the defendant who's leaking anything. He's not even a defendant yet. His team isn't even on the case yet. Mainstream media was getting stuff. How? Not from some defendant that's not named yet and the team. So I will say that I agree with Shannon Gray and Steve Gonsalves on that timeline back in January of 2023, that you guys are leaking stuff and you guys have not protected the integrity of this investigation. Also, I believe that Shannon Gray and Steve Gonsalves knew that video surveillance in that area was not preserved and not got in time. And somebody was telling them to shut the fuck up. Shut the fuck up. You keep blabbing your mouth, then the defense is going to find out what we didn't preserve. And it's going to come out in my live tonight or tomorrow night when I talk about Ann Taylor is one smart fucking woman. And it's going to be the title, Ann Taylor is one smart motherfucking woman. It's going to be my title. And how she was handling the lay witnesses in this case. because the Moscow Police Department, after Ann Taylor uploaded the lay witnesses and the prosecutors got it, right? They turned it over to the police, and guess what they started doing? The police started calling Ann Taylor's witnesses and asking, have you received a subpoena yet? And what have you told Ann Taylor? And what has she asked you? Has she contacted you? 30 people were contacted. 30. And guess what? Every time you have to make a report. And guess what that would mean? Ann Taylor would get that report. It's part of discovery. It's a report. And guess what Ann Taylor did? You'll find out. She's smart. She knows their games. Number 27, 6/11/2025, defendant's motion for access and fair investigation. The state objects to the unsealing of this item pursuant to, as it involves an ongoing investigative proceeding. Again, they're going to hang tight to this right here. And they're going to say, hey, this may be, this should be prosecuted. Okay. So for fair trial is how it has to stay sealed. So I'm curious how that cookie crumbles. And the defense for number 27 here, the defense has no objection. The defense has no objection. The defense has, so if you can see, the defense has nothing to hide when it comes to this special investigation. And because I'm telling you, the defense is not the league. The defense is not the league. And I have a feeling if you got some really good investigators around the defense team, don't you think, because what they're doing is they're handing each other their own investigations on, here, this is how we can prove that the leak came from this, right? That's the type of work product that they're talking about. And I think that if you got some really good investigators on your side, you could be pumping a lot of information. And the defense, hey, put it all out there. Prosecution, no. This involves, because there may be fair trial rights implicated. So I'm curious on how Hippler answers the fair trial rights. That's all I care about, is to hear that. I want to hear how he talks about this. Because I don't know. I would think because if it's an ongoing investigation, the material, when there is an ongoing investigation, right, we don't get material, but there is no gag. Is there, since the non-dissemination order was lifted, then there really isn't a gag. So I guess it's just going to be interesting. It'll be interesting how what he says about that. Number 28, the motion to seal, defendant's motion for access and objection to court's order. The state does not object. That's 28. The defense does not object. Now, number 29, the witness list. Defendant's second amended phase 2 mitigation witness list. Now, the state does not object to the unsealing of the defendant's second amended phase 2 mitigation witness list. However, the state requests that the court redact non-law enforcement potential witnesses. All witnesses identified except 22, 26, and 38. In addition, all personal data. So, again, anybody that's a lay witness. And the defense is saying that they're objecting. There's a continued media attention, including social media and online sleuths and public harassment reasons. I don't, their livelihood of person's names. I mean, order staying order. The state leaves the unsealing of this item to the court's discretion, which is interesting. And the defendant has no objection to the unsealing. So the order staying order. The defense has no objection. And then the state is saying, you make the call. Well, it's going to be unsealed. But for whatever reason, the court doesn't want to have a say in that. Or the state doesn't want to say anything. Thought that was interesting. Order sealing defendant's motion and order for emergency order. So this was all of the state leaves the unsealing of this item to the court's discretion. The defense, no objection. So I think that's going to be fair game. The order, the condition, the order for the conditionally denying admission of additional exhibits as evidence at trial. The state has no objection. The defense has no objection. So I just think this is crazy. Do you guys see that like this whole thing was ready to go to trial? The way that Hippler had this all set up, that like you had to have everything in and ready to go. So the only thing that you would have to do is work on your, you know, I guess you could say the way that you would want to have your witnesses be presented and the questions that you're going to be asking your witnesses. But if you had to have all the exhibits and everything all ready to go, I mean, like all the work, all this prep work, this is wild. All for nothing. Number 30, I think it's down the list, 32, 33. Let's go to 33. Order granting defense expert analysis of evidence. The state does not object to the unsealing of this item. This was in June. The defense objects to unredacted release and requests redaction of the expert's name and address. So I think it's all going to come on. We're going to get it all. We're just not going to know the expert's name because this is the order granting defense expert analysis of evidence. 34, the state's response to the defendant's motion for independent analysis of evidence. So this is the motion. So I think this is all going to become unsealed. It's just going to protect whatever the expert's name is, because the state says the state does not object to the unsealing of this. So the state's saying, you know, the state does not object. The state does not object. The 32, 34, or 33, 34. When we get to 35, it's the motion for an emergency order. All they care about is the names. 35, she's like, just unseal it. 36 is the motion to seal defendant's motion in order for unseal it. Stipulated motion to the admission of additional. So they stipulated. See, that's interesting. That if they stipulated this, then why were you conditionally denying admissions of additional exhibits? If they stipulated to something, usually it's just ordered as it is stipulated. Here, Hippler wasn't having it. So I want to see that. Maybe it would have been like, nope, I'm seeing the exhibits before you think you're just waltzing up to the fucking Hector projector and throwing something up there. You know, this is very sensitive material, something like that. Motion for independent analysis of evidence. That was in June 6th, which is what would have led to all the stuff here. So, because remember, we're working backwards. So right here is the motion of independent analysis of evidence. I can't wait to read this. I cannot wait. I want to know what evidence they wanted to be independently. Like, hey. June 6th, state's objection to defendant's offer of proof. The state requests redactions of any potential witnesses' names other than that, and they want their names in their entirety. They don't want initials. And Taylor says basically the same thing. So we're going to see everything. We're just not going to know the names. That's how it should be. Order granting access to sealed record. The state leaves the unsealing of this item to the court's discretion. The defense has no objection, so this is going to be unsealed. Exhibit S1 to state's supplemental response to defendant's request for discovery. This is an exhibit. The defense has no objection to unsealing with anticipation that the witness's names or a witness name, there's a couple, that they be redacted. And that all has to stem around, this is the 23rd supplemental request for discovery. And so, remember, because we're working backwards, so then you see like item 40, like 444, 0, 439, 438, okay? So I believe Ann Taylor got up to the number, I mean, something in the 450s. She had 450 additional discovery requests. So like, let's see, for example, let's say that I saw this report and all I saw was a report. I'd have a discovery request. And sometimes you can make a simple discovery request that would be like informal. But if Ann was doing everything formally and just through the record, but if I just got this and no attachments, as you can see right here, I FOIA'd ISP email. I want the initial email. So whatever wouldn't be in it. That I also would say that, well, it's interesting that Gilbertson wrote up a report, but Payne didn't. So I would be asking for Payne's report from this to see if why he didn't have a report. I mean, come on. And then I could show in court, you didn't write that report until after we asked you for one, right? Okay. And that's kind of how it went for everything. So anyways, we get to the bottom here, and this is all just about the discovery 423. And these are items 438. The Bates numbers, again, I really, really like Bates numbers for what I do. 439, the pathways, 2 references, an AV number for this item should be redacted as this is an attorney work product. All it does is make it really hard for someone like me to get something like that. The potential witnesses, they should be redacted. He's not. What is your basis to be able to redact AV numbers and redact Bates pages? I'm curious on how he rules on that. And then Exhibit V, defendant's 23rd supplemental request. And this would be just the state requests the following redactions of defendant's Exhibit V, which is item 44 or 444, which is the potential witnesses' names. And so what's interesting is these requests here are literally naming witnesses. And so it would be like something like this. I'm asking for such and such names, interview that he did with so-and-so from this report number, da, da, da. Where is this audio? And then they're over there saying, we already gave it to you. I didn't ask you about if you gave it to it. Where can we find it? Okay. We can't find it. So since you just have such ease locating things, or hey, I asked this person, they told us you have to have it. They told us you have it. Da, da, da. Like I'm playing circle jerk here, and I'm going based off of this report, and it's saying that Mike Van Leuven said that he, sent these swabs, did the phone, sent it to MPD. Where's Jack DeCour's phone? We don't have his cell. Where is this shit? Like, we've been asking for it. Mike Van Leuven said that he gave it. ISP doesn't have it, and that MPD has it because he gave it. But I don't see a report that Mike Van Leuven transported a goddamn thing to MPD. So where the fuck is my shit? I'm looking at your reports that you're giving me, and Mike Van Leuven just says that he went and did. Like, this is chain of custody. Where, Mike Van Leuven? When did you go and give anything to anybody? Where are these reports so that I can track this shit down? What day did you do it on? Like I'm trying to give them something so they can look up in their system. Hey, what came in on November 19th? What was checked in on November 19th? Okay, did you guys put where you're, if it's in the evidence locker, hey, it's in this section. That's where we have this hard drive, blah, blah, blah. Like, come on. I cannot wait for the Shanna Gardner case because talk about a shit show of discovery. The judge basically told Shanna Gardner's prosecution team that they are worthless sacks of shit. And I was like, damn, girl, go on with your bad self, Judge Kite. I swear, the cases I've been covering lately, or maybe I just like I'm watching, but a lot of black judges, and I love it. Like, I'm like, go. She's like, y'all need to get it together. Judge saying, y'all need to get it together. Okay, Judge, I see you, Judge. She's like, what is, because she's a, prosecutor. And she's like, I don't understand how you can't get the discovery. We had to push back this trial a whole year because you guys can't properly. And then they totally, God, they're going to get this. Dude, Jose Baez is going to break Detective Johns over his fucking knee like a little 5-year-old. This is going to be, I would not want to be him. All right. What else? Oh, last thing. Informants. Look at a little peek here. You know what? I'll leave it for later. That's good. We'll leave it right here. Thank you guys so much. Yeah, join me on that. The Shanna Gardner case next October. It's going down. We'll be starting to prep for that. There's no gag in that case. Thank you, moderators. Welcome, William. Let me see what we got here. William, thank you again so much. Yuri passed out 5 memberships. $10 super sticker. Love and appreciate you, Lana. Is it Mal? You go by Mal? One of my best friends' name. Mallory, we call her Mal. Malison? Is that right? Hair of the Dog. Lana, please do another show on the Adelson trial. I personally am a fan of Donna Adelson's female attorney. I think she's rock star. And I think that limiting that dude from speaking was genius. After voir dire, I was like, this dude cannot resonate with this jury. That can mean you might as well not even have Donna. Bye-bye. Went with the female. She's doing a good job. Gifted 5 Truth and Transparency memberships. Joe, thank you so much. Hair of the Dog, the bit your cat's ass. I have one device on you and one on trial. Oh, for the Adelson case? Love it. Love it. I just don't, I'll leave it for another live. Thank you guys. CC and see now. I think this is really heavily explaining why when people are like, why isn't Cyray talking? Dude, this is nothing to mess with. Like, I can't help it that people that I want to talk to are smart and are like, hey, there's like all the stuff is still sealed. There's this special investigation into that leak. All this, like, yeah, duh. So I can't help it if mainstream media hits up people and they get boners and want to go on mainstream media to get their name and their company out there. Like, okay, well, you're a fucking fool. I wouldn't be doing anything if I was an expert in this case with what is still circling. So I'm good. Everybody should be good. Integrity matters. The truth matters. Transparency matters. And we paid Ann Taylor. We paid her whole team. Come on, cough it up. Redact the names. The rest is golden. I don't think any. I think Hippler's going to feel the same way. All right, take care. Till next time. Peace. Batch 1 over and out. I think Hippler's going to start ripping them out. So hopefully as soon as I get them, pump it out. But those are the replies from batch 1. 43 replies, 43 documents. Cheers.